Welcome to this webinar titled, Hi everybody, welcome to this webinar titled Don't Get Sued, Legal Essentials for Massage Professionals, featuring Conscious Counsel Legal Services Company. This webinar is brought to you by Massage Magazine Insurance Plus. I'm Karen Minahan, editor of Massage Magazine, and today's presenter is Corey Sterling. Corey is a lawyer, small business owner, group fitness instructor, and yoga teacher. He has served hundreds of clients in the health, spa, and fitness space throughout the world. Corey has also presented at conferences around the world, teaching about the law in a fun and practical way. So in today's webinar, Corey will discuss legal essentials for massage therapists as 2022 approaches. If you have any questions, please enter them in the chat field or the Q&A, and you will also receive an email with a link to a replay of this webinar within a day or so. Welcome, Corey.
Thank you, Karen. Thank you so much for having me. This is so much fun.
Great.
Now, do I go? I guess now it's just me. I go off.
It's just you.
Spiel.
You're on.
Okay, cool. Yeah, I feel on today. I feel really on. Some feedback that I've sometimes gotten is that in addition to being a lawyer, when I wear these headphones, people are like, "Oh, are you a DJ also?" The answer is no. I don't know anything about being a DJ or what that would be like. But part of me is like, this is a cool thing about lawyering. We're wearing these headphones, which is really great. So I'm so excited for for the opportunity to talk about legal essentials and not getting sued for massage professionals. It's something that I'm really passionate about. Now that I think about it, like I haven't had a massage. Maybe it's been 2 or 3 weeks, which feels like 2 or 3 weeks too long. But in the interim, I have worked. We have worked with a lot of massage professionals. So what I'd like to do before we get started from everyone, and this is because I'll introduce myself and talk a little bit about what I do and why I do it. But first things first, if everyone can just go in the chat and throw in where it is that you're tuning in from. So you're gonna say where you're tuning in from, but I'd like you to also mention a delicious snack that you've eaten today or something you plan on eating today. So I'm gonna go first, and coconut water sounds about right, doesn't it, for me? Some mixed nuts, the word of God, delicious. Santa Cruz, amazing. I think my buddy Ian Finn is out there. Fruit smoothie, Dallas, green apple, Las Vegas, yogurt, granola, sushi rolls, take me. Homemade veggie soup, yes please, cantaloupe, Kings Mountain, pineapple, chai latte, blueberry waffle. Whoa, that's incredible. Cuban sandwich. John Testa has to be in Florida. I was going to say that. Granola, and later Aussie Bites. Aussie Bites from Costco, dangerous. Dave Briggs from Pittsburgh, trail mix, Vermont, and eating pomegranate, antioxidants just filled. Horchata, drink. Jorge, ¿cómo estás? Sounds delicious. Cocoa baton wafer cookies. Latkes, Gilad, Chag Sameach. Seafood soup in Missouri. It's like, I feel like so many of the typical foods that we should be eating, we're eating. The person in the South has a seafood soup that's so perfect. And ice cream sandwiches, Bethany, maybe you take the cake, or is it the ice cream for all of that? So that's really cool. And so firstly, I just think I'm so happy to be with Massage Magazine and be connected with so many people all over the United States who are eating such a diverse amount of snacks. Like, how great is that, if nothing else? The other reason why I want everyone to sort of just get comfortable in the chat is because what I'm about to say is the most important, and this is as follows. Please ask me questions. The entire framing of why I give my time to Massage Magazine and why I love this relationship that we have. I understand as massage professionals, you don't have, it's not that often you speak to a lawyer who really understands the industry or the different things that you're going through. Luckily, I'm here today, and I'm happy to share the information that I have, and I really look forward to doing so. And so please just ask questions about anything that you want. Just feel free to, whatever it is that comes to mind, Awesome. And I see that Jose Ortega already put a question in there. So we'll get to that in a second. But please, it's a service for me. I'm happy to be here. And so we're gonna get rolling right now. The one thing that I'd like to do, I'm gonna start off by sharing, is that we have something that we call a free massage checklist. So I'm gonna post here in the chat. It's a link to a Conscious Counsel massage checklist, and you'd be like, "What's a legal massage checklist?" When I started this business, I found that with various massage professionals, I was having the same conversations over and over again. I was like, "Oh well, if I just keep having the same conversation, then what I think makes sense to do is just give people a roadmap and let them know, like, okay, well, these are the typical issues that you're going to want to think about, or issues that are going to come to mind, or problems that we see clients struggling with." So one of the most common things that I'll hear from clients will be like, "Oh, I don't know what I don't know. I don't even know where to start." If you find yourself in that particular group, the legal checklist is a great place to start. So feel free to get that. I share that with love. And in hope of providing as much information as possible. So very, very quickly, just about me, and I'm sorry that I don't get to meet all of you in person and learn about you guys as well. I'm a lawyer. I started a law firm 5 years ago called Conscious Counsel. We've won 2 awards. We've got more than 275-star reviews. When I started, it was me by myself. Now there's a big team, which is awesome. But the idea was always to make law fun and to simplify the process of law, because the reason I used to work for a big law firm, and my clients were like tobacco companies and mining companies and everything that I stand against, that I'm not for. And I just said, okay, well, I want to start a law firm and I want to work with health and wellness professionals. And the reason why I want to do that is because health and wellness professionals in their own way are making the world a better place. So it was really a pay it forward type concept, where I just thought, okay, if I can work with people who are doing good things and I'm able to support them, then by virtue of having them set up legally with the right documents and the right processes, I too then will, I'll feel confident like I'm making a positive contribution. As a side note, I thought that whatever was happening in law before was pretty boring and sucked. So I was like, we could probably do it better than this, right? It's like, when I look at that list of snacks, I'm like, we can look how creative everyone is and coming up with delicious foods to eat. And it was like, I was like a lawyer and the snack was just like boring crackers and cheese. And I was like, why don't we just get creative and do things differently? So that's a little bit about me. So the title of this, oh, Kathy, thank you for that. I'll move somewhere quieter. Thanks for letting me know that. Another thing about me is that I live in Brazil. And in Brazil, where I'm staying, there's a kite. I'm a kite surfer as well, in addition to being a wellness lawyer. So is that better? Cool. Okay. Thank you. Thanks for the heads up on that. So, okay. So the purpose of this talk and the reason why we're doing this is it's called Don't Get Sued. So the most important part to understand how we can come up with an approach to not getting sued is understanding, okay, in what situation will we get sued and what is something practical that we can do in order to prevent ourselves from getting sued. And so the first thing that I'm going to talk about, there's 2 things that I want to talk about. If everyone has a pen and a piece of paper, I'd like you to write your name or your business name in the middle of the paper. And then I'd like you to draw a line to all the different relationships that you have in your business. So for example, let's say you're renting a space out. Maybe you have a landlord, or maybe you have a rental agreement. Let's say you have your clients, you have a service agreement, you get them to sign a waiver of liability. Let's say there are people who work with you. They could be contractors, they could be employees. And you basically have your name in the middle with a line to all of the pieces of paper. Now, the goal of what I want you to do in order to be the best legally protected possible is to, with each of those relationships that you've established, you want to have a legal document, something written that communicates your expectations of working with those people. So, and the reason I'm going to share why communicating expectations is such an important part of this. Communicating expectations is when you're working with someone and you can tell them upfront at the beginning, hey, we're about to start a working relationship. And in doing so, this is what you can expect from me, and this is what I can expect from you. So as an example, a lease is a very standard agreement where you're communicating expectations. If you've got an employee agreement or a contractor agreement, you're communicating expectations. If you've got a service agreement for your clients, you're communicating expectations. And so now you might be thinking like, okay, Corey, why is it so important to communicate expectations? And I have a good answer for you. I've done this for 5 years. I've worked with more than 1,000 health and wellness professionals in my time. Every problem that I've seen come up is a result of some lack of communication of expectations. So two parties were in an agreement about something, and there's maybe an elephant in the room, or someone just forgot to mention something. The relationship begins, the relationship continues. No one ever mentions, something's unspoken, then there's a problem that arises. And then that problem is what escalates everything into things becoming more and more of a problem. So so far, none of this requires any form of legal education. This is just me sharing my experiences of what I've learned in doing this for years. The best strategy to not getting sued is to have different documents for the different people who you have commercial relationships. And the goal of each of those documents is to communicate your expectations openly and honestly. The reason why we want to do that is because the most problems that would result in a lawsuit or a potential lawsuit will arise because there is some misalignment on expectations. So something was unspoken, something was unclear, we didn't know what would be happening, and then that problem is the issue that blows up and then can result into a lawsuit or things getting more dramatically blown out of proportion. So as much as law is a really complex area, I'm on a crusade to make it as simple and basic as possible. And in this context, what I have to tell you is the first thing you can do not to get sued is to make sure that you have documents that communicate your expectations openly and honestly. Everyone can do that. You don't need a lawyer. You're halfway there if you're able to take that step. Now, the next thing that I want to talk about as a precursory before we get into any specifics around the law, and then I'm going to open the floor to questions, which I hope there are some, is the next most important step to not getting sued is, and this feeds off of the first point, the importance of having written documents, having agreements that are written and signed and legally binding. So you may not think like that it's really that important, but what I'm now going to do is explain to you the process of what happens when you get sued and why it's so important to have documents ready so that in the event that something happens or there's an issue or a problem that arises, that you can quickly resolve it using the documents itself. So, okay, I wish I could see everyone so I could say hands up, but give me a thumbs. Is it possible? Well, no, I can't even, I don't even have a gallery view to get a thumbs up from everyone. But basically, yeah, maybe just like type your favorite word in the chat box if the following scenario makes sense to you or if how you think it goes. So this is how your mindset goes. Your mindset goes, okay, I'm getting sued, which means I'm going to go to court and I'm going to get cross-examined and I'm going to need a lawyer and I'm going to be in front of a judge and all of these things are going to happen. Like, just put something in the chat box if when you think like, oh, I'm going to get sued, that's what it looks like. And the reason why I usually get people to do that or to think about that is the reality is when you're actually getting sued, that's not how the process works at all. And there's more than it's well over 90% a settlement rate for what legal issues that arise. So this is how the process actually works, okay? The process actually works as follows. Thank you, Caroline and Heather and Eric and Kathy, for acknowledging that that's how you think things go. That's how I thought it was before I was a lawyer. Also, just very quickly, Gringo, come here. That's my dog, Gringo. Hey, come on. So he's really sweet and he's well behaved. So like he can be off leash. I have another dog that has to say, sit, sit, sit. What a good boy. Okay, that's enough of Gringo. Okay, so this is what actually happens. What actually happens is some problem arises, remember there's some misaligned expectations, or someone suffered damages, or someone's been injured, or something's happened, the first thing that's going to happen is you're going to receive an email or a letter. And that email or letter is going to be like, hey, Corey, you're bad and you made a terrible mistake. And because you made this mistake, I'm going to sue you and you owe me $37,000 and all these problems and blah, blah, blah. Now, so it's not like you never get sued right off the bat. You always get a demand letter, either in the form of an email from someone, or if you get a letter from a lawyer that says, hey, you did this wrong to my client and they've suffered wrongs as a result. Now, at that point, and this is like, if you listen to one thing, please listen to the following. The life cycle of that issue and your ability to quickly resolve it will be determined mostly from your first response to that initial demand letter. And this is what I mean. Someone's going to say that you did something wrong. Ideally, in a best case scenario, you have great personalized, customized legal documents that reflect, the intentions that you had in entering into a relationship. And you're able to respond right off the bat. Hey, I told you that we were going to be doing massage and that there also might be some reflexology, and there's going to be Reiki, and there's going to be acupuncture, and there's going to be all these different things. And yes, I understand that you did suffer an injury, but the waiver of liability included the possibility of that specific injury taking place. And as such, you also signed away your legal right to sue us. Therefore, based on everything that you've shared, you do not have this legal right to bring an action against us or me. And, if you move forward with a claim, I reserve the right to counterclaim for legal fees and expenses and all of these things. And that's a situation where something can go from being really scary, really intimidating. I'm going to talk about waivers of liability first, so I'm going to make sure that we get to it. But I just want to sort of finalize this point. The whole point here is when you have the documents in order at the start, you can have that initial response. Your initial response can be, hey, you know what? I'm really sorry that you got hurt, or I'm sorry that, you feel that you were an employee, even though, we hired you as a contractor, as an example. Here's the documentation that supports the intentions that we had. It's a legally binding signed agreement. And as such, you will not succeed. And if you bring a case against us, we reserve the right to bring an action against you for damages, for further damages. Now, the opposite to that, so that's the best case scenario. The opposite to that is a situation where you don't have those documents. And so then someone sends you a note and they say, Corey, you're a bad person and you made all these mistakes and these are all the damages that I've suffered, and whatever dramatic legal letter they're going to write you for $37,000. But if you don't have those documents, or like the documents you copied from someone, your first response, you're not going to have that clarity. You're not going to have that confidence. You're not going to have that ability to say to someone, hey, you're totally wrong. And this is, and then you just say, if you bring an action against me, I'm going to counterclaim you for fees. Usually that makes someone goes away. But if you don't have the documents and you're scrambling, what's your response going to be? Your response is going to be like, oh no, well, actually, I really didn't. But, I told you that I was going to be using hot oils or hot stone therapy or whatever it is. And once someone at that point, if that person realizes that you don't have the appropriate documentation in place to protect yourself, they're like, it's like a shark smelling blood, or I don't know. Do sharks have yeah, they have to have a sense of smell. But isn't that crazy to think about? How can sharks smell if they're underwater? That's what I'm going to spend Wednesday night thinking about. But it's like when a shark sees blood, we'll keep it safe. It's like when a shark sees blood, they're on it. And if someone has an issue and your first response is not able to conclusively dismiss that, then they can gain momentum and then they can choose to move forward and hire a lawyer. And then you're going to end up settling, and it's going to cost a lot of money that you could have avoided otherwise. So I'm going to pause there. Once I'm going to see, I see a couple of questions are coming in. So I'm going to let Karen let me know what those questions are. But before I get into the legal issues, just a summary of what I've spoken about so far is just, the best ways of not getting sued is making sure that you have agreements written for each of your relationships. And that the goal is to communicate your expectations openly and honestly, because most of the problems will arise when there's a misalignment of expectations. And then secondly, the reason why you want to have good documentation in place and everything written down is so that in the event that there's a demand letter or someone reaches out to you with a complaint, you can conclusively, turn it away and show them that you have the right legal documentation, that you have the stronger legal position, and that if they bring an action against you, that they'll lose and that you can counterclaim against them. And then I also introduce you to my dog, Gringo. So, Karen, I'll let you hop on and you can let me know if there's any questions. And then once we answer those, I'll get into a couple of the specifics around specific legal areas.
Yeah, hi. So this is Karen. So Lavon asks, she wants a clarification about the waiver of liability. She's wondering if it should actually say that the client does not have the legal right to sue. Did you hear the question? Okay. So Corey, it seems as if you're muted.
Wow, thank you for that, Karen. Thanks for unmuting me there. I had such a great answer that I was going to give. I'm still going to give it. Okay, so what a waiver of liability should say, and I'm just going to take this and I'm going to run into waivers of liability, and I'm going to do it pretty quick. And this will answer the question, and if anyone else had any questions about waivers, hopefully this will address it as well. Now, the waiver of liability is a really, really important document. And the reason why the waiver of liability is such an important document, and it's actually more important than the other documents in terms of not getting sued, if we're staying with this theme of not getting sued, it's because when you're entering into a relationship, a legal relationship, and you sign an agreement, let's say with your clients, let's just say on a service-based agreement. So I offer massage, it's $50 per massage, and let's say something happens, and okay, hypothetically, in that relationship, assuming that no one gets hurt or no one gets injured, my liability is at a maximum going to be, someone wants a refund for all the massages I've done with them. Let's say I've done 4 massages in the month of November. Okay, so that's $200. I can manage paying $200. I have a service agreement. I put in no refunds. I put in no cancellations. I put in no guarantees, whatever, all that stuff. But I know going into that, okay, it's going to be $200. Let's say I'm renting a space and I have a space rental agreement. I know that I pay $1,200 a month. And, in some situation where for some reason I'm unable to pay or I'm unable to use the space and I don't do so for 2 months, I know the amount that I have to pay is $2,400, right? And that was good math, by the way. I don't know if anyone caught that. I was just like, whoosh, just smooth, just really got it. I think it's okay that I make myself laugh. I don't know if these are funny jokes or not. But okay, but a waiver of liability is different, and this is why insurance, Massage Magazine Insurance Plus, this is what we're talking about. When it comes to a waiver of liability, the damages of, if you make a mistake or someone gets injured or suffers really significant damages in working with you, we don't know what that total is going to be. It's not as safe as the $200. It's not as safe as the $2,400. It's, liability, quantum of damages, if someone sues you and someone's unable to work anymore because of something that happens, God forbid, can be very, 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 very hundreds of thousands, millions of dollars. So the reason why you want a great waiver of liability is because of all of the areas where you're most vulnerable to be most liable. It's going to be here in this area if someone suffers damages as a result of the services you offer. So law and insurance are like Batman and Robin. They work together. They're awesome. They're amazing teammates forever and ever. And, Massage Magazine Insurance Plus is where you're going to want to go to make sure that you're in all of your insurance matters are taken care of. So, these are the services that I offer. This is how I offer them. I want to make sure that I'm covered. What's my deductible? All those sorts of questions you're going to want to figure out, and you get your insurance taken care of. When it comes to the waiver, the last thing that I'll just say as I intro waivers of liability is just one basic legal concept that everyone understands. So at law, there's something that's called a duty of care. And a duty of care means that the law has decided, whether you like it or not, that in certain relationships, one person has a responsibility to make sure another person does not get injured or harmed. So in this context, a massage professional who is providing services, professional massage services to another person, to a paying client, at law, you automatically have a responsibility to make sure that that person does not suffer damages through the duration of the massage that you're giving them. So you have a duty of care. You don't get to choose. It's not like, okay, yeah, I accept this liability, or no, I don't. It's automatically there, so it automatically applies. The purpose of the waiver of liability is that the waiver of liability says, okay, we get that this duty of care is here, and that if something happens, that the massage professional is going to be liable. However, if the client signs a piece of paper called a waiver of liability, where they relinquish their legal right to bring an action against someone who they're participating in an activity with, if that person signs a waiver of liability and it's properly drafted, that duty of care will be nullified and the person will have signed away their legal rights. So what a waiver is someone is waiving legal rights that they otherwise would have had. So, hey, normally there's a duty of care, and if I injure you or you get injured in the scope of our services, I would be responsible to make you whole and complete. But because you signed this particular document, you've relinquished those legal rights, but the document only works if it's drafted properly. So now if everyone has a pen and a paper, I'm going to go through the 6 elements that need to be present in a waiver of liability. And again, remember just the big picture perspective for all of this. What's happening? Like, why are we here? We're here because the law takes signing away of legal rights very seriously. Especially in North America and the Western world, we take individual rights and freedoms very, very seriously. So the courts have said, if someone's going to be signing away their legal rights, the document has to, meet a particular legal test in order to actually be valid. So that being said, the first thing that needs to be listed, the first element, is going to be a description of the activities. So that is what is it that we're doing together? Okay, we're doing massage, we're doing Reiki, maybe we're doing cupping. I'm a crazy cupping fan, by the way. Maybe we're doing reflexology, maybe we're doing Thai massage. I don't know, I'm sure of everyone who's on this call, there's some super cool things. If you do something really unique, throw it in the chat. I'd love to see what it is. But you have to list what the specific activities that you're doing are. And the whole reason why you have to be specific about the activities is that if you're not specific about what those activities are, then someone can't sign away their rights. Like, you can't sign away your legal rights to something you don't know that you're getting into. So as an example, let's just use hot stones, right? Okay, I sign a waiver that it says I'm receiving massage and it's going to be amazing and soothing and whatever, and it doesn't say anything about hot stones. And then suddenly you're using hot stones, and the stove that you heat them on or something happens, and then I get burnt by either the oil or by the stones or by whatever it is. Acupuncture is awesome too. I'm so happy about that. Okay, so now legally what the person would say is, oh, well, you didn't tell me there's anything about hot stones or hot oils. I never signed away my legal rights around that, and therefore I can still bring a claim against you. So element 1 is activities, and we want to be specific to the things that we're doing in terms of the activities that we offer. The second is, what are the risks? So number 1 is activities. Here's what we're doing. This is the equipment we're using. This is where the services take place, all of the things. The second question is, what are the risks that are involved? So I'm doing the following activities. What things can happen? I could receive burns. I could have injuries. It could be soreness. It could be broken bones. It could be, concussion or post-traumatic stress disorders. It could be all of these different things. We have to list all of those things. Element 2 is, what are the risks? Element 3 is, what are the outcomes of the risks? So now I've participated in the activity. The risk itself has materialized. And now what does that mean? It means, okay, there may be, external skin rashes or damages or blemishes on my body. It could mean extreme discomfort to the point that I'm unable to work. It could be a significant change to my quality of living. There's all these different possibilities of what the outcomes of the risks are. And these are really, every element is equally important, but these big 3 are the ones that are the most difficult to get right for massage professionals. So I'll just repeat them again. It's the activities, it's the risks, it's the outcomes of the risks. Once all of that has been clearly laid out and organized, the next thing that comes up is, okay, you've told me everything. I affirm that I'm healthy enough and that I understand it's my responsibility to share with you if I have any medical conditions that are conflicting. Your intake and your waiver form are different. Your intake and your waiver form are different, and I'll speak about that at the end. But okay, affirmation of health. Someone says, you've told me what we're doing. I'm healthy enough to participate. The next one is voluntarily participating. Okay, cool. You've told me what we're doing. I'm healthy enough to participate, and I choose to do so on my own volition. I'm voluntarily participating. And then lastly, I release you. I release any contractors. I release the building. I release whoever, Gringo the dog. You release all parties and say, I release and am not allowed to bring a legal action against any of you. And those are the elements of a waiver of liability. So I'll just repeat them one more time so that we're all on the same page. And then Karen I'm sure there's a couple of questions that have come in, and I'm also going to scroll through the chat to see the cool things that people are up to. So it's the activities, the risks, the outcomes of the risks, the affirmation of health, voluntary participation, and then ultimately the waiving of liability, the waiving of legal rights, which essentially is someone saying, I agree that I cannot sue you. I waive my legal rights that I otherwise would have because you've informed me adequately about what it is that we're doing together. So Karen, if there's any other questions around this, I'm happy to take them.
Yeah, sure. So Jose asks, what happens if his insurance does not cover all of the modalities he offers? Is there a way to still cover myself either via the waiver form or another type of insurance? Yeah.
What's up, Jose? Nice to meet you. I guess if this is a way of that people meet each other. But you definitely, if your insurance is not covering you for some modalities, you 100% want to make sure that the waiver of liability does. Yeah, so you're going to want to, if the insurance does not, then you're going to want the waiver of liability to cover you for that. In terms of seeking out additional, insurance, that's never a bad idea if you're able to find as much as you find it. So my answer, like I was on a call yesterday, and the answer is you can never be too careful. You can never protect yourself as much as possible from my perspective. So you want your insurance, you want your waiver, and then in the event that something's missing or you're a little bit short, do everything you can to make sure that you're totally covered. And again, the best thing that you can do is speak to your insurance providers and have clarity about what you're covered for, what you're not covered for, and then make sure that the legal agreements have you, and then possibly look for additional insurance coverage.
So we have another question from Kathy, who asks, how do you respond? What if a client doesn't want to waive their future rights?
Clients are certainly entitled to do that. And like there's an expression at law, which is that two parties can agree to anything that is not illegal. So what the significance of that is that if you're trying to get someone to sign an agreement that says, hey, I'm not going to hold you responsible and I refuse to sue you if something happens, and the client reads that and they're like, actually, no, I don't agree, then that's like communicating expectations up front, which is just the whole, everything that I spoke about at the start. And then you have a choice as a professional to work with that person or not work with that person. But if you continue to work with them, you have to understand that in the event that something goes wrong, that duty of care is untarnished and still exists, and they can bring an action against you if they want. And it's your choice whether or not to work with them. I'll just give an example. For me, in my law firm with Conscious Counsel, anyone who signs up with us has to sign a client welcome agreement before we accept any money from them. And the reason why we do all of that is just because, hey, these are the expectations of what we have in the people we work with. If you're not on board with that, then it's probably better if we don't work together. And I know it's never fun to turn people away. But having said that, sometimes when you understand that there's a potential problem at the start, it's much better than figuring out there's one at the end.
Mhm. Okay, we have another question that came in from Spiridon asking, is the waiver signed once for every client or signed by the client at every session?
Spiridon Dimitrakulas. Let me know if I got Dimitrikalous. Definitely Greek, right? I feel like I can say that with some certainty.
Beautiful name. Yeah.
Yeah, that is a beautiful name. The way that it works with waivers is, remember how it's all about activities and risks. So the way that we do at our law firm, the waivers have a particular provision in it, which says, okay, you understand that so long as the activities and the risks and the outcomes stay the same, that we do not need to re-sign it. But what you should know is that in the event that you add new activities, or that you're adding something new, or there's new risks that may come up, you're going to want your agreements to be modified to cover that. So the answer is that so long as the agreement is properly drafted, you could get it done one time, and then it's done. But then the moment that the activities or the risks change, then you'd need to get them to re-sign. So just as an example, like the whole COVID thing, when COVID was just sort of starting to happening, and we were updating agreements, we sent out an email to all of our clients and we're like, hey, send us your waivers. We want to revise them for you because there's a new activity and there's a new risk, and we want to make sure that all of your clients are releasing you for those activities and risks.
So that's all the new questions that we have right now.
Okay, fantastic. And I saw Sally's up to some really cool work. Shirodara sounds awesome. I'm not sure exactly what that is.
It's Ayurvedic. It's from Ayurveda, using lots of beautiful Ayurvedic oils.
Oh, please. I was in Kerala in India, where Ayurveda started, and they have some really fascinating treatments that I'm sure everyone knows about. It was really interesting. Tie wood and hammers amidst scraping. Yeah, for Toxin, for tie wood and hammer, you're going to want to get that in the waiver. Acupressure-ish, Jinsu, Jutsu, bamboo fusion. Lomi Lomi, Karen, what's Lomi Lomi?
So Lomi Lomi is originated in Hawaii, and so it's really broad, beautiful strokes using the forearms primarily.
Oof.
Yeah,
I could use some of that. Also, Karen, what do you think about maybe doing a Jeopardy game where we get people to share the different type of massage services they offer, and I get to ask you the questions, because it seems like you know everything.
What is effleurage, Corey? For 500.
Well done.
We have another question come in that I'd love to ask.
Yeah,
I just need to get back up there just a second. So Angelica asks, are Google Forms legally binding if you include an explanation that this is the client's electronic signature and acceptance when they type in their name to the form?
So the thing to know is that, and this is about the process of using documents, it's less about, like, Google Forms in and of themselves are fine, but there's a particular process that you have to go through with your clients. So what the process is as follows. Someone has to be present before you start working with someone. Someone has to be presented with an agreement or a document, and they read through that agreement. And once they read through the agreement, they can either sign their name with their hand or electronically, or they can click, I agree to be bound by these terms. But once they do so, then you can accept money from them, and then you can start working with them. But if it's possible for someone to sort of like not sign it or not read it completely and then try to get out of it, they possibly can. So Google Forms in and of itself is not like that. In and of itself is not a bad form, and it's not like there's good ways and bad ways, but you just want to check the process to make sure that you're capturing and keeping all of the different the different information that you're collecting, and B, that you have to make sure that people have to go through and read it. And I'll just tell you why, Angelica. The reason why is because, look, if someone's going to try to get out of a legal agreement, they're going to do everything they can to find every reason why they should not be held accountable, or why the agreement should be void, or that it's not really, it's not binding upon them. And I can tell you, if someone went through a Google, whatever, I'm not particularly belittling Google Forms, but I'm just saying that If someone were to send me an email and say, hey, Corey, I want to hire you. I signed this waiver, but it wasn't done the right way. Can you look into the process and come up with a legal argument? I could, unless it was like airtight, great process, really well done, I could come up with an agreement, an argument, likely. And then remember what that does. Remember the first step I said about not getting sued, of someone sends a demand, you want to respond with your agreement. Part of what you want to do in responding to that is showing the process of being like, you signed this agreement on this date at this time, and but you went through the following signing sequence where you were presented with the agreement in full, you clicked I agreed to be bound by all of these terms, and then we took your payment. So if people are trying to get out of things, that's understandable, and that should be anticipated. And like, as a lawyer, I feel like I'm really not a fearmonger at all, and I feel like I'm an optimist. But what I will say is, like, desperate times call for desperate measures, and if people are going to try to get out of an agreement, they're going to do whatever they want to do so. So I hope that helps.
Thank you. We have a couple more questions that have come in. Curtis asks, should we have a separate release of liability form related to COVID?
No, COVID can be part of your waiver. That can be one.
Yeah. So Levon asks if Massage Magazine has a simple example of a waiver form. And I tell you, we'll get together with Corey and see if we can put something together for you and get that rolling. And then Renee asks, she has a concern that there's a possibility of potentially losing clients if they see a waiver listing lots of risks like burns and broken bones. She's concerned that we're putting negative thoughts out there for the clients on board. So
cool, Renee. I'm sorry that you feel that way. I've just been through so many situations. I've been through so many settlements. I've been through so many problems that, to me, the answer is, first thing is, like, most of the clients aren't even going to read that, and it's sort of like, before you go in a car every time, I understand where you're coming from, because it's like when we go into a car, it's not like, well, these are all the things that could happen when you're in a car, when you're driving on a highway, whatever, all the bad things that could happen. That being said, what I care about is, in the unlikely event that something happens, that you're protected. And I can tell you that, it's all about communication with your clients. It's all about painting a picture to them. And you just have to say, I've started working with a new lawyer, and this is the recommendation that they have. In the history of my business, this has happened 0 times, but I still need to be protected in the event that it does happen. And it's totally personal choice. You're going to do what's good for you, Renee. You do what you're comfortable with and what represents your brand and your business. But I've just seen simple mistakes made too often that cost a lot of money and even more stress. And, I've just been through a lot of really crappy situations that, for me, it's non-negotiable, but ultimately it's your business, so it's your choice.
So Nicholas has a question regarding massage therapists who might be doing work that brings up emotional reactions or traumas that go beyond what the client might have expected in a massage session.
Yeah, you'd want to list that in the waiver of liability. And like we also work with a lot of coaches and health coaches, and that's part of it too. Part of what it is that's coming up is that you're accessing different parts of the brain and with different emotions, and that it's possible that there will be side effects and there will be transitions that people go through. And again, so long as you let people know what they're getting into, they can properly sign away their legal rights against you. So you do want to make sure those are covered.
And Bethany asks, is there a difference between what we're calling an informed consent document and a liability waiver?
Yeah, I've always called it a waiver of liability or a release of liability. Informed consent, I've never used that vernacular really. And again, if you think about it, remember how this is different than all of the other agreements, and this is about signing away legal rights. And informed consent, to me, someone could possibly come up with some form of argument or something to say where they're like, oh, well, I didn't realize that I was signing away my legal rights when I signed an informed consent form. But someone would not be able to have that argument if they signed a waiver of liability or a release of liability.
And John asks that many times his clients don't really read the waiver carefully. They just kind of skim it. And he asked if
Yeah,
he should worry about that. And so I think he's really asking,
no.
like, should he really make sure that the client knows exactly what it is they're signing?
No, you shouldn't worry about that. And the reason why is because so long as the process is in place where they have access, before you work with them, they have access to read the entire document, and they click something that says, I agree that I read all of the, the entire content of this waiver of liability. And by signing here, I'm signing away my legal rights, something to that effect. It doesn't matter if they read it or not. Ignorance is not a defense in that particular context.
Okay. So we're coming up on almost an hour for this webinar. Do you want to keep going for like several hours longer? Yeah,
I'm happy to keep going. I also, there's two quick things that I just want to share about in terms of like offers or next steps, if any of this resonates. So I just put a link into the chat. I've started a new business that's called Laws Fun, which is basically customized legal documents without like the legal relationship. So there's no support, there's no edits, there's no back and forth. And it's at a much lower price point than it is for the legal services that we offer. And we're still like, we're in beta testing phase. So I've opened the website up for all attendees of the webinar. We're going to close the site again tomorrow because we're still just sort of fine proofing it. But basically the way that it works is instead of having a relationship with a lawyer and edits and comments, you would purchase one of the documents. They're currently at 50% off. And again, like we're pulling this tomorrow, but I just wanted to give everyone a chance. You would purchase the document, you receive a link, you answer questions, and then you get a finalized, customized version of the document that you can use. And if you have questions about how to use the document, we support you with that. So that's something that's really cool and exciting. We're going to be launching it later in 2022. But I just thought, I think I've done a few of these with Massage Magazine. We love the community. So I thought it would be cool to, just offer 50% off to anyone who is looking for these documents. And then the other thing that I'm going to add right here is a link to book a free consult with me. The intention of the consult is, you've heard some of the information. I've only really touched on waivers today and speaking generally about not getting sued. But I also just shared a link to my, to book a call with me and chat. If you want to work together, if you're looking for more of a personal relationship and understanding what it is that you're doing in your business and what legal help that you need, I'm here to work with you. So that being said, the next thing that I quickly want to talk about, I've got 10 minutes. And again, like, firstly, this has been awesome fun. I think this is a Massage Magazine for me never disappoints. The delicious snacks really got me off on the right foot. Also, Gringo sent me a text message and he's like, that webinar is fire. Like, I love them. I was feeling the love through the screen. So, anything that makes my dog happy makes me happy as well. So, so I'm so thrilled. The next thing that I just want to talk about, and for Laws Fund, we only have 3 documents for massage professionals. That's the privacy policy, the waiver, and then the service agreement. So I want to talk a little bit I'll talk about privacy policies literally in 1 minute. Privacy policies are all about the personal information that you collect and the rules that surround them. So if you want to take a nap or you're looking for the cure for insomnia, reading a privacy policy it's actually the answer. It's medically proven that reading a privacy policy will put you to sleep. They're very long, and it's all about just meeting the requirements of what government says. So government says, okay, well, if you're processing someone's payment online, or you're collecting email addresses, or any information that you're collecting from people, you need to have a privacy policy posted to let people know what you do with that information and how you're using it. So that's what the privacy policy is for. And then it also is the terms and conditions for your website, as well as a social media disclaimer. So social media disclaimers are important because we all go on social media and we're like, yeah, this is, amazing. And I want to reference one of those unique types of, I lost in the chat's too big.
Hey, Corey,
Corey, yeah.
If you put anything else in the chat, can you select the option to send it out to everyone?
Oh.
Yep. I copied and I also want to let everyone know you can click the 3 little dots in the chat box and save the chat if you'd like to do that. So you can
Got
save
it.
all those
Okay,
lines.
Karen, thanks for the heads up. So what I'm sending out now, everyone, is a link to the Laws Fund website with the docs for 50% off that we're pulling tomorrow. And so you'll see Laws Fund is in the link there, and then the second one is to book a call with me. So thanks for that heads up. And then I'll just wrap up on social media disclaimers. Basically, we all go on social media and show how awesome we are and how we're able to help people in so many different ways. You want to be protected in that case. The tricky thing about social media and website is that you don't always know who's visiting you and what it is that how they're using the information that you share. You want to be really clear about listing your qualifications, about letting people know, where you studied, what you do not do. Also for massage professionals, especially as we go to a few of these more esoteric types of practices, you need to be really clear that it's not medical services, that people need to see a medical professional, and that you recommend all of that stuff. So all of that's really important. And so that's one of the documents, the privacy, the terms of service, and the disclaimer. And then the third document is a service agreement. And this is like, for massage professionals, we've seen this be really effective and really important. And this is basically the document that you have with your clients. And it outlines the working relationship and what the expectations are and what you're going to do and what you're not going to do and what your qualifications are. And if you need to cancel, and there's no refunds and there's no guarantees and all of those sort of things. And if just to sort of bring this all full circle to the first thing that I was chatting about in terms of communicating expectations openly and honestly. So again, and I just repeat a few of these points over and over again, because I've been through this and I can tell you the most pertinent and the most important points. So the reason why you want this document for you and your clients is because all of the issues that I have to resolve as a lawyer come up around some form of miscommunication or not communicating expectations openly and honestly. And it's sort of like, you do it once, you set it up properly, you have, an agreement that lists exactly, that tells people exactly what it is you're doing with them and how you're doing it, and what the working relationship is going to be like. And in the event that there's a problem, and this is really where the power comes in the event that there's a problem or some form of misalignment, then you're able to explain to people like, hey, well, when we started working together, this is what we said around payments, or this is what we said about, auto pays, if you work on an auto pay system or whatever it is. And it's so much more powerful when you have a professional document customized for the services that you offer, to be able to, frame that and share that. And, responding from a place there, what I always say to my clients is the best response to someone is, hey, I'm sorry that, you're disappointed with this, or that this isn't working for me. When we started working together, we both agreed ABC, but clearly it's not happening. So how can we restore integrity into the relationship? And it's very, very healthy. The most important relationships that you're going to have as a massage professional is that with your clients. And there's certainly, in addition to legal protection and helping you keep the assets that you collect and revenues and all of those things, it's just really a key to good relationships. And I'll give an example, just a personal example. Like there's someone who I work with who's my bookkeeper, and my bookkeeper's been under the weather and for 2 months hasn't really done the services that they said they were going to do. And there's no written agreement, there's no contract. And I just got an invoice for this current month's payment. And I sent an email. I'm like, okay, well, what are we doing here? Like, I've been paying you, you haven't been doing the services, you don't have an agreement. And it's just uncomfortable. I don't really want to work with this person anymore. And as massage professionals, we want to do everything we can to avoid that, and to not only have customer retention, but also referrals as well. So those are really the big three that we work with. It's the waiver of liability, it's the privacy, the terms of service, and a social media disclaimer, and it's also a service agreement. So we've got 3 minutes. Karen, did any other fun questions come in?
Yeah, we got a question from Kathy, who just has some concern that it could cost a lot to prepare 3 documents.
Okay, well, look, I can tell you the Laws Fund option is it will never be less expensive than that. I think we've put each document at 50% off, so it comes about to $900 for 3 documents, which is compared to what other lawyers would cost. That's reasonable. But look, it's what I can tell you about law is that law is an investment in protecting your assets. and the risk. And unfortunately I've seen it, and like, it's not fun in the same way how it's not fun for me to pay a bookkeeper and for me to pay an accountant. And like, I would way rather spend that on awesome treats for my dogs and, doing other things that I want. But there's a particular cost of doing business, which is important to understand as an entrepreneur. Some things are more fun to pay for than others. Like, Instagram ads could be really fun to pay for, or paying for a new website would be more fun because that's a creative, innovative project for you. But what I can tell you is, if you're operating your business and you're trying to work with more people and you're trying to grow your business, inevitably you will interact with the law. So you want to be legally protected for when and if that comes up. And like, the first lesson I learned as a lawyer came from one of my mentors, and he's like, you're going to tell your clients they can pay you now or they can pay you later. And what that means is, like, eventually they're going to have to work with a lawyer. And if you pay someone now, you pay something like, okay, $1,000 for 3 documents, not fun, but I'm protected. Conversely, when you have to pay someone later, that's after you've gotten a demand letter for tens of thousands of dollars, that you then not only do you have to respond, you don't have a strong position to respond to, but you're in a weak position to respond. And then in addition to that, you're going to spend months being stressed out and worried and not being able to service your clients because you're focused on that particular problem. So that's my answer. I get that it's expensive and it's different than other fields, but it's a protection in your business.
Okay, thanks. So anything else, Corey? Is it okay if I pop on and thank you? And
yeah, do it. I would just ask if everyone listening had fun, just put the word fun into the chat. And just that's really what I'm going to go to sleep thinking about tonight. If English is not your first language, I'm speaking Portuguese these days. So I put divertido, which means fun, dog treats. Yes, Nicholas, we got it. So love you, Massage Magazine. Thank you so much for the opportunity, Karen, and I'll hand it over to you.
Yeah, so stay on. I just wanted to come back and say thank you so much for the fun and inspiring talk, and for being so generous and sharing so much information with our audience.
Cool. It's a treat. I'm always here, and we'll do it again next year. And in the meantime, guys, reach out, book a call. Happy to support you. Tomorrow morning, we're closing the website, but if you want to get in now, always happy to work with massage professionals. Keep being awesome, make the world a healthy place, and eat good snacks.
Thank you, Corey. Thank you, everyone.
Ciao. Bye-bye. Thanks for having me.
Okay, bye.
Gringo.